Thank you very much. This provides an opportunity to provide a much more service to our students from primary onwards, and so therefore the elimination of reading recovery is going to be better value for our dollar because more students will be served.
The honourable member for Colchester North on your first supplementary.
Thank you. Also in question period yesterday, in response to a question, the minister responded that she had consulted with experts regarding this decision, but she failed to identify the experts. So my question to the minister is this: will the minister please identify the experts with whom she consulted and when those consultations were held?
The Honourable Minister of Education.
Thank you very much, Mr. Speaker. I made a decision, and I stand by this decision because it is good for the taxpayers of Nova Scotia and for the students as we rebalance our system, that our money that we're asking balances out with our decreasing enrollment. Thank you.
The honourable member for Colchester North on your final supplementary.
Mr. Speaker, I'm a bit concerned because that's conflicting with the information she gave yesterday. Her response that she consulted with experts. She's now saying that she made the decision, so I'd ask for some clarification. At the Public Accounts Committee, Mr. Speaker, on March 9th, the Deputy Minister of Education was reported to have said that one of the reasons for eliminating reader recovery was to address budget restrictions, and I will table that. With the price tag for reading recovery being $7 million at the time and the replacement program being $5 million, my question to the minister is this: is the minister really telling Nova Scotia parents, teachers and struggling young readers that losing the opportunity to learn to read at an early age through a research and evidence-based program is worth $2 million in a $1.1 billion budget to this government?
The Honourable Minister of Education.
Thank you very much, Mr. Speaker. This minister is saying that the children of this province will be able to get support earlier in primary and to be carried through when they need support. We are making sure that we are meeting the needs of our children sooner. So this minister is not taking away, this minister is adding to.
The honourable member for Inverness. Order, please. Order. The honourable member for Inverness has the floor.
Thank you, Mr. Speaker. Mr. Speaker, a lot of Nova Scotians were left scratching their heads this week when the government posted an actual surplus for the previous fiscal year. This fiscal year just ended. Their numbers were out by about $600 million. So, Mr. Speaker, the deficit of this province, we believe, was closer to 3%. And, Mr. Speaker, to put that into context, when Dr. John Hamm was Premier of this province in 1999, the deficit formed 10% of the operating budget for this province. So to put it into context, in 3 years, that deficit was eliminated by good, prudent fiscal management. Will the minister not agree that last year's budget could have been balanced through modest fiscal restraint?
The Honourable Minister of Finance.
Thank you, Mr. Speaker. Let me inform the House of a few facts, Mr. Speaker, when we're talking about things like debt. Mr. Speaker, the largest accumulation of debt in this province was during a 4-year period shared between Conservatives and Liberals, where the debt went up $4 billion in 4 years. Mr. Speaker, the largest 2-year increase was $2.3 billion under the Conservatives, and the competition came from the Liberals, who had a 2-year increase of another $2 billion. But, Mr. Speaker, the record in Nova Scotia for the largest increase in debt in a single year, $1.473 billion in a single year, belonged to the Conservatives.
The honourable member for Inverness on your first supplementary.
You know, Mr. Speaker, I, for one, am tired of the whining and complaining that this minister does. And I'm going to give you one example, Mr. Speaker, where this minister could have done something last year, and his government had promised that they would reduce the size of the civil service by 1,000, positions. And we learned from public accounts a couple of weeks ago that about 600 positions people leave every year on their own accord, and nobody is hurt by any loss of employment. So this government, will the minister agree that his government, had they kept to their word, could have eliminated 250 positions, 1/4 of that goal last year, and saved the province approximately $25 million if you look at the cost of the salary, the benefits, the technology, and, Mr. Speaker, the office space? At $100,000 per employee, 250 employees, that would have been a savings of $25 million, Mr. Speaker. And that, curiously enough, would have been probably enough to give Nova Scotians a break on their personal income tax. So will the minister not agree that my numbers could help him, if he had a fiscal restraint bone in his body, to bring our budget closer to being balanced? Mr. Speaker.
The Honourable Minister of Finance.
Mr. Speaker, I had a very nice family dinner in a Chinese restaurant last night in the riding of the member for Bedford-Butch Cove, and I was stunned by the fortune that came out of my fortune cookie. It says, quote, "You have balance."
Order, please. No props in the legislature, please. Order, please. Order, please. You want to? All right, you can table it then. Thank you.
It's a document I intended to table. It says, "You have balance and foresight, and you can envision the ideal direction that events should take." End of quote. And I asked myself, Mr. Speaker, how do they know? But, Mr. Speaker, here's the reality of Nova Scotia's finances. In the last 35 years, that party over there has been entrusted with government twice, and each time they have left nothing but financial wreckage behind.
The Honourable Member for Inverness on your final supplementary.
Mr. Speaker, I think that when our finance minister is starting to read fortune cookies and bringing the results into the legislature, maybe it's time for another finance minister. But, Mr. Speaker, I do take exception to his comments. The Auditor General in this province agreed that the Conservatives brought 8 balanced budgets from '99 right through 2009. And they eliminated a deficit that was 10% of the budget in 3 years. And, Mr. Speaker, this government should do the same. I would ask a question here, Mr. Speaker, but I believe we're running out of time.
No.
I have time.
If you ask it right now, you'll have time.
Will the minister not agree that the HST increase last year was not necessary because he ran, after all, a surplus last year?
The Honourable Minister of Finance.
Mr. Speaker, when that government left office, they left wreckage behind, and it was left for us to pick up the pieces, Mr. Speaker. And in consultation with the people of the province, Mr. Speaker, we developed a good plan, a back-to-balance plan. We will be back to balance in 2013, Mr. Speaker. We will continue to provide quality public services to the people of Nova Scotia, Mr. People. That is what they asked us to do, and that is what we will deliver.
The Honourable Member for Bedford-Birch Cove. Time has elapsed for oral questions by member. The Honourable Member for Richmond on a point of order.
Mr. Speaker, on a point of order, quite often during debate in this House, either during question period or elsewhere, sometimes members may get a bit excited and use language which is clearly not only, if not unparliamentary, goes beyond the bounds of decency. Mr. Speaker, following a question by my honourable colleague from Preston to the Minister of Service, Nova Scotia and Municipal Relations on a topic for which our caucus has heard from municipal leaders throughout the province in their anxiety regarding government's decision, the Honourable Government House Leader made a commentary which was clearly heard by not only yourself, Mr. Speaker, I believe, but all members of this House, all members in the gallery. Mr. Speaker, as I'm sure you're aware, quite often Hansard will pick up the comments made by members of this House who may not actually be the member standing and speaking, and I would certainly hope that those comments that were made by the Government House Leader would not show up in Hansard, but at the same time, I know that the Speaker has been called upon to rule in the past when members have made comments that were either unparliamentary or beyond the bounds of decency, even if they were not actually in their place when those comments were made. I would ask that you look at the comments, which I believe you heard very clearly, made by the Government House Leader following the question put by the Honourable Member for Preston, and hopefully ask that those comments be withdrawn. And certainly, I've chosen not to repeat the comments in the hopes that they do not show up in Hansard, the official record of debates here in the House of Assembly.
I will take that under advisement and report back to the House at my earliest convenience. And now we're on the subject of point of orders. I would like to and have a review on the point of order raised by the Government House Leader respecting the resolution tabled by the member for Dartmouth East. I believe the third whereas could be taken to associate the Premier with lying or having himself lied. And I feel the inference is unparliamentary, so I'm going to instruct the Chief Clerk to delete the third whereas from resolution number 257. Thank you. I will now recognize the Honourable Government House Leader.
Thank you, Mr. Speaker. Mr. Speaker, could you please call government bills for second reading?
Government bills for second reading.
Could you please call Bill number 7, the Justice Administration Amendment?
Bill number 7, the Justice Administration Amendment. The Honourable Minister of Justice.
Thank you, Mr. Speaker. Justice Administration Act, second reading. Mr. Speaker, I move that Bill number 7, an act respecting the administration of justice, be now read as a second time. I am pleased to rise in the House today to introduce the second reading of this omnibus bill that proposes an amendment or repeals several acts under one bill. In this case, all the changes that are being proposed to the various pieces of legislation are housekeeping changes intended to clean up the legislation. Mr. Speaker, let me take a few moments to outline the specifics of this bill. Essentially, the Justice Administration Act proposes minor changes to 6 pieces of legislation that rests in 2 departments, Justice and Labour and Advanced Education. The acts included are the Estates Act, the Indignant Debtors Act, Forcible Entry and Debtors Detainer Act, Civil Services Collective Bargaining Act, Corrections Act, Highways Workers Collection Bargaining Act. Mr. Speaker, the bill proposes to repeal 3 acts that are outdated: the Estates Act, the Indignant Debtors Act, and the Forcible Entry and Detainers Act. These acts all date back to before the 1900s. Mr. Speaker, we have consulted the Nova Scotia Barristers Society and determined that these acts are no longer being used in the current practice of law. In addition, Mr. Speaker, all these acts have been superseded by other pieces of legislation. Mr. Speaker, the other changes being proposed are also straightforward. The proposal is to remove the words arbitral and arbitratable with regard to the terms of employment from the Civil Service Collective Bargaining Act, the Corrections Act, and the Highways Worker Collective Bargaining Act. Mr. Speaker, last fall, the term arbitralist was removed from these same statutes. In many collective bargaining agreements where the parties cannot strike or lock out, disputes that could not have been solved at the bargaining table went to the arbitration. There were parameters around the conditions of employment that an arbiter could include in these settlements, and these forms what used to be called the arbitral list. Mr. Speaker, feedback from lawyers and unions indicate that the arbitral lists slowed down arbitrations as there were often disputes about what the topics could be arbitrated. Despite the list, and some disputes had to go to court to be resolved, it could be a lengthy and costly process. So a reference to the arbitral list were removed in 2010. Reference to the arbitral and arbitratable remained. Mr. Speaker, the Department of Labour and Advanced Education has had feedback that lawyers and unions find this confusing. Removing the remaining reference to the words arbitral and arbitratable from these pieces of legislation will eliminate possible confusion over the jurisdictions of interest arbitration boards to arbitrate labour relations issues. Mr. Speaker, this does not change the meaning or the intent of the acts. It cleans up the language and makes the acts more understandable. Mr. Speaker, in closing, I would like to once again reiterate the purpose of the Act respecting the administration of justice. Mr. Speaker, the changes being proposed will simplify the legislation and make the justice system more efficient by keeping legislation current and understandable and removing the legislation that's not being used. Thank you, Mr. Speaker.
Member for Richmond.
Thank you, Mr. Speaker. It's a pleasure to rise and speak on Bill number 7, the Justice Administration Amendment 2011 Act. Now, Mr. Speaker, at some point I'm going to have to question whether what I've been saying in this House for the last 13 years or so is actually being heard by the governments of the day, or whether I'm repeating myself and it is falling on deaf ears. And you may wonder what specific part of what I've said in the past is not being heard. Well, Mr. Speaker, the Justice Administration Act is a way that government can bring in a number of changes to different pieces of legislation all under one act. Now, in the past, that has been done for relatively minor changes. Changes so minor that one would argue it didn't warrant having a standalone act. Now, last session that we were here, the government, the new NDP government, seemed to have been listening in one sense, but even went further in bringing in such things as the Clothesline Act and a few other acts, which it was hard to argue why they should be standalone pieces of legislation. And not only that, I recall the Clothesline Act, while it had initially come in this House as a private member's bill, actually was introduced as a government piece of legislation as part of their plan for Nova Scotians. But, Mr. Speaker, where we run into problems with a Justice Administration Act is when the government puts in changes to legislation which are such that Nova Scotians who could be impacted don't fully appreciate the changes being made, because the title of the Act certainly does not give any indication of the changes which are contained within. So, in the past, as I mentioned, we have seen significant changes hidden in these Justice Administration Acts, not only by this government, but by the previous Conservative government as well. And I certainly stood in my place and made those complaints against the previous Conservative government. And I recall being joined in those complaints by a former member of this legislature, former House Leader for the NDP, Kevin DeVoe, former member for Cole Harbour Eastern Passage, who, as well as while justice critic, agreed as well that making significant changes to legislation under a Justice Administration Act is not an open and transparent way of changing the laws of Nova Scotia, because those Nova Scotians at home that could be impacted are not given full notice of the changes being made. So we've seen that in the past, as I've indicated. I've raised it in the past. So now let's look at what's in front of us today. My argument has been, if they are minor changes that somehow are linked together, that's very easy for Nova Scotians to understand why the changes are being combined, then there shouldn't be an issue. So when I first started looking at this act, Mr. Speaker, it appeared to be an act that was going to make some changes to the wording of collective bargaining agreements here in Nova Scotia. So in that sense, it seemed to be something that wasn't of great concern, or at least on the face of it, it doesn't appear to be changes that would have significant concerns. But as you keep reading through the bill, all of a sudden, without getting into the specific clauses, Mr. Speaker, I'm sure you'll rule me out of order for doing so, but the other acts which have been thrown in here, I can't think of a better way of describing it, but thrown in, is repealing the Indigent Debtors Act, the Estreats Act, and the Forcible Entry and Detainer Act. Now, I'm very curious if anyone on the government side could explain to me how these 3 bills have anything to do with the changes to collective bargaining agreements in the province of Nova Scotia. I would argue that there's absolutely no correlation there at all, but they're thrown not only at the very end of this bill, but they're mixed in into changes to the collective bargaining agreements. So without wanting to be a conspiracy theorist, Mr. Speaker, we can't forget what we went through with Bill 100, the last session of this legislature, where this government looked to make major changes to labour relations in this province and tried to hide it under an omnibus bill. And we all know the lengthy debate which took place on that, and I believe there's still long-standing damage done to labour relations in this province, and I would submit to you, Mr. Speaker, there's been long-standing damage done to the credibility of the New Democratic Party and the New Democratic government as to whether they can be trusted when it comes to the issue of labour relations in this province. So one would think that after what we went through, where we had major corporations in this province, respected lawyers in private industry who came in front of this government and made presentations, one would think this government would be extra sensitive to ensure that no one is under the impression that they're trying to pull a fast one when it comes to issues of labor in this House. Yet here we have the Minister of Justice bringing in a Justice Administration Act which makes changes to the Civil Service Collective Bargaining Act, the Corrections Act, and the Highway Workers Collection Bargaining Act, and at the same time repeals 3 pieces of legislation which the Minister of Justice tells us have not been used in 100 years. How do you draw the link between those two? The Minister would tell us that as far as the Collective Bargaining Acts, he's removing the word arbitral. Now, I'm sure most Nova Scotians are wondering what the definition of arbitral is. And I can tell you, I heard the Minister use the word in various pronunciations, and I'm not even going to try to repeat them because using the word arbitral is challenging enough, to say the least. But, Mr. Speaker, this is basically cleaning up changes to collective bargaining acts as a result of Bill number 100, which was passed before. Arbitral, my understanding is that it provides a list of some of the issues which could potentially be words of conflict. If actually one looks at some of the helpful information that was provided to us by the Department of Justice, it actually includes what was on the old arbitral lists that were removed in 2010. And I'll just mention a few, Mr. Speaker. I know the Minister of Transportation is following along, which I appreciate. There is, for example, the issue of wages and salaries, pay procedures on promotion, demotion, reclassification and increments, hours of work, overtime compensation, premium allowances for work performed, holidays, vacations, and many others which apparently were causing issues as regards to some of the disputes which may take place between, in this case, the employer being the government and I'm assuming the government employees union, or whichever union is representing the civil servants, because obviously my understanding is the highway workers fall under a different bargaining unit and a different union than the rest of the civil servants here in this province. So again, knowing what happened with Bill number 100 and the anxiety that caused to private industry, the Canadian Federation of Independent Business, the Restaurant Association, everyone else that were concerned that the changes being made there would somehow impact labor relations in private industry, one would think that if government's bringing in changes to collective bargaining acts, which they say are minor in nature but are merely a reflection of what was done, they'd leave it at that. And that this Justice Administration Act would only deal with changes to the Civil Service Collective Bargaining Act, Corrections Act, and the Highway Workers Collective Bargaining Act. But instead, they throw in 3 old pieces of legislation that are being repealed, that they say is no longer in use in Nova Scotia. And my question is, why? Why wouldn't you simply bring in another Justice Administration Act to make it clear the government isn't somehow trying to muddy the waters of what's really happening. Because of this, Mr. Speaker, I should advise at this point that I believe there will be some lengthy debate on this bill in order to allow the exact same individuals who had concerns with Bill 100 to carefully examine Bill number 7 to ensure that there isn't the same level of anxiety that was in Bill number 100. And the government has no one to blame but themselves for this. Because, again, not to be a conspiracy theorist, but if you actually follow through on Bill number 7 as it goes along, Mr. Speaker, it starts off by indicating the changes to the Civil Service Collective Bargaining Act. Then it goes on to changes in the Corrections Act. Then in the middle of it, after that, it goes on to repeal the Streets Act. Following that, it repeals the Forcible Entry and Detainer Act. Then it goes on to changes to the Highway Workers Collective Bargaining Act, and it wraps up with changes to the Indignant Debtors Act. Now, Mr. Speaker, if someone can follow along the logic of how that flows, I'd be very curious to hear that argument. Because when we looked at this, we were left wondering, why would you throw in 3 pieces of legislation which apparently, according to the minister, have not been used for 100 years, in with the same bill, that you're changing the wording, specific terms involved in collective bargaining acts, which the minister has indicated has caused confusion and has caused issues. Why would you mix it in? What is the purpose? And unfortunately, it leaves us to draw the conclusion that there may be something more to this than what it would appear on the surface of it. When Bill 100 was presented in this legislature by the Minister of Labour, she said there was nothing there for anyone to be concerned about. It was just minor changes being made to legislation in this province. History tells us that many Nova Scotians didn't share the same opinion as the Minister of Labour. In fact, the government was forced to make changes as a result of the outcry that came not only from the members of the official opposition, but I know as well the members from the Conservative caucus, and from Nova Scotians in private industry, those who worked in labour law in this province, who saw what was truly the intent behind the changes being brought forward by the government. Now, Mr. Speaker, as you're well aware, this party, which is now in government, the New Democratic Party, has a very long history of very close ties to the labour movement. We know, not so long ago, for example, that the president of Nova Scotia Federation of Labour sat at the caucus table of the NDP. Well, he did. Look back into history, and I'll show you actually the media article where it was decided he would no longer sit at the caucus table. If the Minister of Labour, I know she's only been here since 2003, but she would do best to ask some of her colleagues who were here from before that date that Rick Clark sat at the NDP caucus table. That is a fact. Possibly the member from Shabukta, who's been here as long as I have, might want to remind the Minister of Labour of that reality. But regardless, Mr. Speaker, there has always been an extremely cozy relationship between Labour in this province and the NDP. I could go through the history of political donations, which had any private enterprise given the amount of money to either our party or the Conservative Party that the NDP has received, it would be a scandal. It would be considered to be outrageous. Yet somehow the Democratic Party felt it appropriate to take workers' money that they pay in union dues to be part of a member of a union in a unionized workplace and use that for political purposes. That's a decision they've made. Unfortunately, our courts, while they have frowned upon it, have not outright banned it from happening. I still remember first year law school that was one of the cases we looked at, was whether when an individual had actually said, I don't want my union dues going to support the NDP party. And the question was whether he could stop paying his union dues because of that fact. So there is case law on that, but as I said, while the courts frowned upon it, they didn't come right out and say that it couldn't be done. So The NDP has done that pretty much since its creation here in Nova Scotia, and we have seen over the years just how significant amounts of monies have been spent by unionized workers here to go towards the NDP, even though many of them don't vote NDP and don't support the NDP party. I have to add, Mr. Speaker, I know in my own case, ironically, in Richmond, I'm not sure why, but the NDP, when they're moving around the union money, has never really put too much money into NDP candidates in Richmond. I'm not sure why that is, but I know they're very strategic in which ridings they do put money in, but Richmond has never been much of a beneficiary, the NDP candidates at least, of union money. But one of the most offensive donations that I saw, Mr. Speaker, was from one of the unions that actually sent money to the candidate in Richmond County, which came from a legal defense fund. A fund that was set aside to fight for workers' rights and to fight in courts was actually used to send to a political candidate in Richmond County. That, Mr. Speaker, for anyone to be able to stand in their place and to say that that is a legitimate use of money set aside to fight for the rights in court of unionized workers, Mr. Speaker, the results speak for themselves in Richmond County, I guess, as to how well that strategy worked of putting that kind of money against for an NDP candidate into an election. But regardless of that, Mr. Speaker, I believe, and I've stood in this House and have spoken at length about that, so allow me again to point out that Bill number 100, for anyone in this province in private industry who may not have thought that the NDP were very cozy with the union movement and with Labour in this province, saw it in Bill number 100. You had Labour representatives saying, everything's fine, don't worry, there's nothing there hidden, it's all okay. And then you had private industry coming in, respected Labour lawyers coming in and saying the exact opposite. And lo and behold, even though the Premier told us at the end of the day that everybody was wrong, although if I'm not mistaken, I pretty much heard that again today in question period, where regardless of anything he was asked, everybody was wrong. When our leaders told him, you know, you raised the HST by 2%, the Premier said, no, you're wrong. I'm like, he's wrong. Well, I expected him at the end of the day to be truthful, Madam Speaker, is when the Speaker recognized him as being the Premier, I expected him to stand up and tell the Speaker, you're wrong, I'm not really the Premier. It was becoming that much of a farce in question period today in the responses we had from the government. But the message is very clear to private industry, is that this government can't be trusted. So because of that, they're relying upon the opposition, the official opposition, leadership being shown by our leader on Bill number 100 and on all other pieces of legislation to hold this government to account. Because this legislature only opened last Thursday. The bill before us was only tabled on Friday morning, and now it's up for debate. And I don't believe that there's actually been any media coverage of the legislation. So unfortunately, once again, we're left with a situation where those who are involved in the Labour movement, whether they be private industry, whether they be unionized workshops, whether they be those who work in the legal profession, I don't believe have been fully made aware of Bill number 7 and its possible implications. Again, I repeat how it is that 3 pieces of legislation, which apparently have not been used in over 100 years, have somehow found their way in the same bill that amends 3 collective bargaining acts in Nova Scotia. Mr. Speaker, one of the concerns that were raised with Bill number 100, which actually this Bill number 7 is actually making changes that should have happened with the passage of Bill number 100. So I know some of the members of the NDP are wondering how is it that they tie together, but obviously they were not listening to the Minister of Justice, because he made it very clear in his remarks that this is as a result of the passage of Bill number 100 that these changes now have to be made to these 3 collective bargaining acts. And we're left to wonder exactly what impact will these changes have, and are they changes that are being made in the best interest of Nova Scotia taxpayers? Because the government could possibly argue, well, this has no impact on private industry, it's only dealing with collective bargaining in the public sector. But Mr. Speaker, Madam Speaker, I think it's safe to say that every Nova Scotian has an interest, because at the end of the day, when it comes to the government being the employer, that's every Nova Scotian being the employer. So every Nova Scotian has an interest. And why they have an interest is in situations where you have the Minister of the Public Service Commission say that he has limited increases to public sector workers to 1%. Yet, as my colleague here from Kings West has pointed out today, yes, maybe the wages for some of the employees was limited to 1%, but in the negotiations, there were changes made to vacation, long service awards, job security, which at the end of the day all have a financial impact on the bottom line and impact the finances of Nova Scotians, who are, at the end of the day, the employer. So that's why you have to keep looking further to see exactly what impact changes made to the Collective Bargaining Act will have. Madam Chair, to say that it's 1% was obviously, as my colleague has pointed out, not an accurate reflection of the cost of government. On top of that, the 1% we were told was limited to unionized employees. Now we're finding out that those who are considered managers and outside of the bargaining unit were given retroactive increases. As well, many of them, I believe we are now finding out in Communications Nova Scotia, were reclassified. So I guess, Mr. Speaker, I can say at the end of the day, and as a worker, if you're offered 1% increase or with reclassification, it's not a bad deal. And for a government to stand in its place and say the impact to Nova Scotia taxpayers 1% is clearly inaccurate. And when the minister was given the opportunity today, well, the raise is 1%. Okay, so raise 1%. But an extra week's vacation, guaranteed job security, job reclassification doesn't add up to 1%. And the Minister of Communities, etc., I'm not sure what the full name of his department is, but I'm just going to call it Communities and Stuff to make it a bit easier. Clearly, at the end of the day, when the minister was given the chance today to answer the concerns raised by the member from Kings West, he just gave a glib reply because I think he was caught. I think what my colleague was doing was exposing what the government has truly been doing, because I know we are sitting and wondering, what is Joan Jessom going to say to a 1% increase when they were clearly saying that they were looking for 3%, 4% more? And yet they settled on 1%, and there wasn't a word said. So right away we asked ourselves, is there more to this? Is there more to this than just a 1% pay raise? And I believe that the Minister of Communities and Stuff has indicated, yeah, there was. 1% was just a salary, but there was also a number of concessions made which will have a significant impact on Nova Scotia taxpayers at the end of the day. And Mr. Speaker, I think with time we'll start looking at some of the initiatives that were put in there, because I think it's quite interesting to see some that have been shared in the media about the type of severance that will be provided to people who work in the province of Nova Scotia. And Mr. Speaker, I would never take away the hard-working civil servants in this province, but I find it interesting that when we have a government that says that some of the MLA provisions are perks and are too rich, I can assure you that the severance provisions offered to members of this legislature unfortunately pale in comparison to what is available under this government for civil servants of this province. And I would question, Mr. Speaker, how many Nova Scotians would see that as being fair or would see that as being right. But those are the types of changes that this government has slowly been making, while on the face of it trying to tell Nova Scotia taxpayers it's only been a 1% increase in pay. It is obviously costing more. And as our caucus has pointed out, when one looks at the projections for the amount of civil servants that will be in this province. We have a government that has said they're going to reduce the civil service, I believe, by 1,000 or 1,100. Yet, when you look at the numbers and the projections in the budget that was presented, it would appear from last year to the following year, we're going to have more civil servants. The government says that's not the case. So then we question, is that just the government trying to pad their numbers so that that will be money they'll be able to move around at the end of the day to once again tell Nova Scotians, lo and behold, we said there was going to be a $300 million deficit for 2011-2012. Look, we've got a surplus. Nova Scotians, I think, have gotten pretty tired of that, Madam Chair. And I know comments that I have heard in my own riding has been, how do you go from an over $200 million deficit projection a mere few weeks ago to then saying we're going to have over $400 million surplus? You know, it's one thing to be wrong by $1 million, $2 million, $20 million, $50 million. It's another thing to be off by $667 million. So this government's credibility has gone out the window. And Nova Scotians are saying, how can we trust them? How can we believe this government when those kind of games are being played with the numbers of the province? Mr. Speaker, that's why when it comes to Bill number 7, once upon a time, we would have said this is just a minor housekeeping bill. But with this government now, with the actions of Bill 100, with their actions on the budget, we're left to wonder, is there more to this than what appears on the face of it? Now, Madam Speaker, when it came to the composition of the new Labour Management Review Committee, which was proposed under Bill number 100, we raised the concerns that while the majority of Nova Scotia workers are in a non-unionized workplace, there's absolutely no representation from the non-unionized sector on this management committee. It is broken down into 5 representatives from Labour, 5 representatives from business that are unionized. So even though the vast majority of employers in this province are not unionized, they are not at the table. So when we had the Human Resources Committee, not that long ago, where these appointments came forward, we raised those issues. We raised the issue, again, of why wouldn't the government take the opportunity of putting a voice to those who are not in a unionized workplace. And I remember the member for Halifax-Chebucto told us that our concerns were unfounded, that there would be absolutely no changes to issues such as the requirements for signing up members to unionize a workplace or any other issues that may impact non-unionized employers. He gave a guarantee on behalf of the government that that would not take place. Unfortunately, that committee had answered, and we will keep that. Although, unfortunately, if the member from Halifax-Chebucto was in cabinet, I would have much more confidence in the assurances that he gave on behalf of the government than having given them as a member of the backbench. But just the same, Madam Speaker, that's why we're left here today with wondering exactly what is it that the government really is intending to do with Bill number 7. Why do they continue to bring in Justice Administration Acts, which clearly do not flow in the changes that are being brought forward? In one sense, you're trying to amend 3 collective bargaining acts, and then you throw in 3 old pieces of legislation in that same bill. It just doesn't add up, and it leaves us with the suspicion that there is more to this, and that's why we want to make sure that Nova Scotians who may be impacted by this have the opportunity to have further discussion on this. Because technically, Madam Speaker, should this bill pass today, second reading, the government could call it for law amendments tomorrow. They could call it for law amendments on Monday. And it's quite possible that Nova Scotians who do have an interest in labour issues in Nova Scotia would have no idea that this has taken place, because even if they were looking online to see what bills were presented, or if they heard the Minister of Justice stand in his place and read out Bill number 7, an act respecting the administration of justice, it gives absolutely no indication of the changes that are contained within. Most of the time, bills will actually have on their title, give you a sense of exactly what it is that's going to be changed in that bill. For example, Madam Chair, when you look at a bill from my good colleague from Dartmouth East that says the Hydraulic Fracturing Act, well, I think that gives you a pretty good sense what that bill is all about, just from its title. One would have to conclude that that may have something to do with the process of fracking here in this province. Or, just to be fair to my colleagues in the Conservative caucus, if one looks at the bill from the Honourable Leader of the Conservative caucus called the Modernising Government Act, one would have a sense of what that bill might entail just from its title. But Bill 7 is called the Justice Administration Act. So one would wonder from that, those either of a legal mind or not from the legal profession, maybe it must be something to do with the Department of Justice. Yet, responsibility for the 3 acts that are being amended here have absolutely nothing to do with the Minister of Justice. He is not responsible for the Civil Service Collective Bargaining Act. The Minister of Justice is not responsible for the Corrections Act, nor is he responsible for the Highway Workers Collective Bargaining Act. Yet those are the 3 pieces of legislation which are being changed, where the government is removing the word arbitral, as well as the list that is attached with these agreements as to what issues may be involved with the term arbitral. So, Madam Speaker, that is why we believe that it's important to give Nova Scotians the time to reflect on what implications this bill might have. I haven't had the opportunity, I must tell you, Madam Chair, to closely look at the Indigent Debtors Act to see exactly what it involves. Having had a bit of a quick look at it, it doesn't appear to be situations that one would want to apply today. For example, in Clause 4 of the Indigent Debtors Act, it says, a person imprisoned upon any order for arrest, writ of capias, or execution or attachment order for non-payment of money may present a petition praying for his discharge. Well, Madam Chair, I'm not quite sure when the last time someone may have made such application here in Nova Scotia under the Indigent Debtors Act. And I'm sure that some legal historian could probably provide us with a bit better sense of when this act may have been used by Nova Scotians unfortunately imprisoned for non-payment of debt. As well, Madam Chair, when we look at this bill and the changes contained, there's as well the repeal of the Forcible Entry and Detainer Act, which, when one looks at it a bit more carefully, tends to deal with issues of arrest and detention for someone who is wrongfully or forcibly entered into lands in case of wrongful detainer, or is withholding with force after possession demanded, and goes on to talk about such issues. Again, Madam Chair, I would wonder when the last time that this act may have been actually enforced here in the province of Nova Scotia. And then as well, Madam Chair, we have the Streets Act, which actually deals with the issue of fines and forfeited recognizance within the power of the province. Again, Madam Chair, this would appear to be legislation which is no longer of use here in the province, but does actually remain on the books of the province. So it was, what did I say, Chair? I do apologize. I noticed someone did that last night, and I said I will not make that mistake. So I do apologize, Madam Speaker, for that error on my part. But the question again is why do you repeal these 3 pieces of legislation? I believe the Minister said they haven't been used for 100 years. Why would you mix that up with changes to collective bargaining legislation in this province after what this government went through in Bill 100? It just doesn't make sense, because they've basically invited us and invited Nova Scotians to draw the conclusion that there might be something more to this Justice Administration Act than what has been presented to us. Madam Speaker, there's a tremendous amount of legislation in this province which remains on our books, which is no longer in force. If I'm not mistaken, and I don't believe it's been repealed yet, there is still legislation allowing Nova Scotians, and I believe more specifically those within the boundaries of the city of Halifax, to bring their cattle to the commons, and that they may freely allow their cattle to roam on the commons here in Halifax. That was legislation I remember we studied in law school, of an example of legislation which still remains in effect, but is clearly not practical in this day and age. I'm curious as to whether the Law Reform Commission may have looked at these specific bills and indicated that the government should repeal them. Because as you may be aware, Madam Speaker, the Law Reform Commission has done a tremendous amount of work here in this province in reviewing existing legislation and suggesting new legislation, and I certainly commend Executive Director John Briggs and all of his team for the work that they have done, and which is why in getting the reports that they provide, I don't recall seeing that these specific pieces of legislation were recommended to be repealed by the government. But the Minister of Justice may be able to provide us with more information on that. Madam Speaker, as I said earlier, Bill 100 undid what had been a relatively long period of labor peace in this province, where everything seemed to be working as it should within the labor movement of unionized workplaces and non-unionized workplaces. But Bill 100 caused concerns for all Nova Scotians, I would suggest to you, as to where the government was going and were they trying to make unilateral changes to labor relations in this province as somehow paying back a favor to the labor movement, which had been so supportive and so generous financially for this party. That was clearly the concern that there was, and I know many Nova Scotians will still be of the conclusion that that exactly was the intent of Bill number 100, and I would suggest to you, had it not been for the work of the official opposition and the Conservative caucus in holding this government accountable, that there would be further changes being made to labor laws in this province in order to favor their friends in the unionized movement. But now I believe the message has clearly been sent that we will hold this government accountable. The Minister of Labour last year brought in a bill leading everyone to believe there was nothing significant in the legislation. And we believe that. Very benign. We believe that because second reading took place with very little debate. It was only afterwards, upon further closer examination, that it was seen that it wasn't what the Minister of Labour had presented. We know better now. So we learned our lesson, basically, I guess is what I'm getting to, is that we learned our lesson. We learned our lesson that with this government, what appears on the face of it, look further to see what the true intent is. The way they've presented this Justice Administration Act, I have to say, is suspicious. Putting in 3 old pieces of legislation in the same act that would make changes to 3 significant collective bargaining acts in this province leads one to question why that is being done. Madam Speaker, Nova Scotia taxpayers will want to make sure that any changes made to these agreements are not only fair to the people who work for the province of Nova Scotia, but are fair to taxpayers as well. And that's why when my colleague from Kings West raised questions today to the minister responsible for the Public Service Commission about what is the true financial impact of the agreement reached by this government and that minister with civil servants, it was clear the minister had no interest in answering the question. Because while he said publicly raises were limited to 1%, we now know that the true cost to Nova Scotia taxpayers is significantly more. Not only today, but well into the future, because that's now something that's been given as part of the collective agreement, and any efforts to change that in the future certainly will be met, I have no doubt, with significant resistance. So that's why, at the end of the day, we question why this government is not being open and accountable with this House, or with the people of Nova Scotia. When we asked the Minister of Finance to explain how an environmental permit increased by $300, and he says it's a cost of doing the business, well, we know that it just doesn't add up. So what does the Minister of Finance respond? He said, I have followed all of my obligation under the Fees Act. All notices have been given. I've followed. That's not an answer, Madam Speaker. That's not telling Nova Scotians why they're paying an extra $300 today than they did 2 weeks ago. That's the type of answer I would have expected from the Conservatives when they were in government, and the Minister of Finance, while sitting over here, would have been putting that same question. But you know what? Even back then, to their credit, I never once heard a Conservative Minister of Finance stand in his place and say, we have followed all the obligations under the Fees Act and we have filed the necessary paperwork. I've never once heard, to their credit, a Conservative Minister of Finance give that type of an answer. Because such an answer is so disrespectful to the taxpayers of Nova Scotia, who legitimately have a right to know when they are going to pay for a service, are they being charged the true cost of government in delivering that service, or are they paying a tax for the service they are requesting? And when the Minister of Finance questions us to say, does the Liberal Party believe that every Nova Scotian should pay for these services? Not at all. But we believe that Nova Scotians should pay the fair cost of the delivery to provide that service. And when you have an increase of $300 for an environmental permit, that is a tax. Because the Minister of Finance himself, if you follow his logic in his answers, he started off with saying, this is a reflection of the cost of delivering the service. And then he went on, I know it was stronger than him and he just couldn't help himself. He went on to say, and we need the revenue to deal with the financial mess the Tories left us in. And that's the real answer. When you want to know why is an environmental permit today $300 more than it was 2 weeks ago, it's to deal with the finances of the province, not with the cost of delivering the service. Because today, we gave the opportunity to the Minister of Environment to tell us exactly what has changed in this department in the issuance of these environmental permits today from last week that has caused a $300 increase. Minister of Environment had the chance to answer, but if I'm not mistaken, he said, I'd like to give that question to the Minister of Finance. So now it's left to the Minister of Finance to explain to us what's going on in the department of the Minister of Environment. And I believe in the next weeks to come, other ministers will have the opportunity as well to either tell us why Nova Scotians are paying more for a service from their department, or they may do like the Minister of Environment and refer it over to the Minister of Finance. And what was amusing, when my colleague from Kings West gave the Minister of Environment a second chance to answer what had changed in his department, he decided to tell us that the environment was going to be great, all was going to be well, clean air, clean water, pay no attention, we're going to take more money from your pocket in order to pay for such things as environmental permits. Madam Chair, Madam Speaker, I don't believe that's what Nova Scotians voted for. I don't believe that's what the NDP party indicated it would provide in government when they were on this side questioning the government of the day on behalf of taxpayers and asking exactly what is it we're paying for and how can you justify those increases. Instead, they've adopted the exact same tactic, but even worse, rather than provide a legitimate, reasonable response. The Minister of Finance, again today, I believe it's 3 days in a row, continues to say, I have followed my obligations under the Fees Act, proper notice has been given, proper papers have been filed. Madam Speaker, again, truly disrespectful of Nova Scotian taxpayers to not give them a better response than that, when at the end of the day you have a government that's trying to say we're giving a better deal to Nova Scotia families, when we all know there's more money that's going to be coming out of their pockets as a result of this increase in user fees. And as I said, we will have time, because if I'm not mistaken, there's 1,400 user fees that were increased, so we've got quite a few questions to ask on behalf of Nova Scotians when you have 1,400 user fees. And Madam Speaker, maybe you'll even talk to the Speaker about granting us extended question periods so we can get a few more in, knowing 1,400 user fees, that could significantly take up quite a bit of time of this House, and unfortunately we're quite limited in the amount of questions that we can ask. But this debate here on bills such as Bill number 7, the Justice Administration Act, does give us an opportunity on behalf of Nova Scotians to raise some of these issues which clearly the Minister of Finance is not interested in answering. We have the Premier now who any question he's given says it's wrong. We're not quite sure what our strategy will be with the Premier next week, because as I said, I fully expected him, when recognized by the Speaker as the Honourable Premier, to say, you're wrong, I'm not the Premier. You know, how do you deal with a situation as such, as a member of the opposition, when you're sent here by your constituents to hold the government accountable and to try to ensure that the tax dollars that they are giving to the government are spent wisely and are spent prudently and are reasonable? When you have a Minister of Finance who gives the type of answer he's given, and the Premier who today, for I believe every single question he was given, said it was wrong. When the Leader of the official opposition said your government raised the HST by 2%, he said you're wrong. How can he be wrong? Everybody knows this government raised the HST by 2%. It's a fact. And I challenge anyone on the government side to stand in their place and say it's not true. The Premier said it's not true. Well, let's go through exactly what was said. The Leader of official opposition said you raised the HST by 2%, you raised 1,400 user fees, and you did not index tax brackets. And they put the question, and the Premier's response was, you're wrong. So which one, and I would challenge any member of the government to stand in their place and tell me which one of those three that the government didn't do. They did them all. They raised the HST, you raised the 1,400 user fees, and you did not index tax brackets in Nova Scotia, because Nova Scotians are now paying more tax as a result. There are only 3 provinces in the country that do not index their tax brackets, which has been referred to as bracket creep. Now, I'm sure most people sitting at home, and possibly even some sitting in this House, have no idea what bracket creep means. But the numbers have been worked out by the Canadian Federation of Independent Business and by others to show, at the end of the day, middle-income families, because of the government's refusal to index tax brackets, will end up paying more tax. Yet, even with that reality, these are non-partisan groups, not affiliated to political parties, who I believe are very legitimate. The Premier says they're wrong, because he would have us believe that by increasing the personal exemption by $250, because of bracket creep, you're going to pay an extra $600 that somehow the Premier would have us believe you're going to come out ahead. Now, only NDP logic would allow you to draw that conclusion. But in all due respect to the Premier, he is the same Premier who got the budget wrong by $667 million. So I do understand that his ability to count and his ability to do math is extremely limited, because of the fact that he has yet to explain to us how he could be off by $660 million. You can blame $193 million on the federal government in their prior year accounting, so let's take that off. You're still off by $400 million that the province has to somehow explain to Nova Scotians how that makes sense. And Nova Scotians are left there wondering, Madam Speaker, that we just finished a fiscal year. We went from a $200 million deficit to a $400 million surplus, and then the Premier and Minister of Finance stand up and say, but this fiscal year, we will be in a deficit again. You know, what Nova Scotian would run their personal household with that type of financial logic? Of going from a significant deficit to a surplus, to turn around and say, I will now finish the next fiscal year back in a deficit. No Nova Scotian runs their household that way, so they're left to wonder, why is the NDP running the province in that fashion? But, Madam Chair, Madam Speaker, I'm reluctant to make predictions, but something tells me that when we'll be standing here next spring, it will not be the $300 million deficit that the Minister of Finance has predicted. Something tells me at the end of the day, the Premier will stand up before the budget and somehow tell us the good times are here again, that somehow we are not going to be in a deficit. Madam Speaker, as I said before, Nova Scotians have grown tired of that. For a party that spent so many years, its entire existence, in opposition, preaching to the governments of Nova Scotia how to be transparent, how to be accountable, how to be truthful and clear with Nova Scotians, only to see that now in power, all of those ideals seem to have been set aside, because now the goal is not to make sure Nova Scotians get the best government. The goal is, how do we get re-elected? That is now what the goal is. Because when a question is put to the Minister of Finance about increases in user fees, and he responds by saying, I have followed the obligations under the Fees Act and have filed all the necessary information, you know that that's not the NDP party that used to sit in opposition and preach to former governments. I know the Minister of Service Nova Scotia, if he was asked that question, would not have given that type of an answer. Now, let me add, we may not like the answer he would have given us, but I know that he would not be able to look at himself and stand in this House and repeat that type of answer. Because I know he does his work, because when he was asked for a definition of clear cutting, he had that definition ready to go. Now, we're not sure where he got the definition. We may not agree with the definition, but he had a definition.
That may have changed.
He didn't hide behind the Fees Act or any other act. He did his best to actually give a definition, so I will give him credit for that. But to see how quickly the NDP government has changed, I have to say, Madam Speaker, while for us it's not surprising, we're not of the same political affiliation, of the same political beliefs, but for those hardcore NDP supporters, when I think of people like Silver Donald Cameron, who supported the party through thick and thin when they had little to no membership but always supported him, I'd love to hear what his take would be on the responses that have been given by the Minister of Finance when asked about user fees. If he would say, that's why I supported the NDP all of those years, through thick and thin, because I thought they would be great for Nova Scotia. I really wonder, and I wonder how many others of the hardcore NDP supporters who have been with them from the days when they had 1 member to 3 members and growing from there, whether they would say, that's the type of answer I wanted to put the NDP in government, so that the Minister of Finance, when asked how an environmental fee went from one amount to an additional $300, that he would stand in his place and say, I have filed all the papers as required under the Fees Act. I don't think you'd find too many, Madam Speaker, that would stand in their place and say, that's why I supported the NDP. Those are the ideals of social justice, of fairness, of a better deal for Nova Scotia families that I was talking about when I voted for the NDP and I sent them money and I worked for them, was for that type of an answer to come from the Minister of Finance. Madam Speaker, as I indicated before, because of these types of responses, because of these types of actions, Nova Scotians and ourselves have come to the conclusion we simply can't trust this government. So we need to do our duty as an opposition to question everything they do, to look behind every bill that they present, to see what is the true intent that they are trying to achieve here. Are they trying to pull a fast one? Are they trying to do another Bill 100? So because of that, Madam Speaker, you are going to see, linked to your debates in this chamber, you are going to see the opposition question everything the government does because of what the actions of this government and the message that they have sent to us. And as I said before, with Bill 100, yeah, we got caught. We believed the Minister of Labour when she told us there is nothing of concern in this bill. It is merely housekeeping changes. We did. Our Labour critic spoke very briefly, being reasonable and trying to work in a cooperative fashion. Second reading went along very quickly, only to find out, lo and behold, what were being presented was not, and in fact, was not accurate. So which left the lengthy debate which took place in the government, even though a majority, being forced to back down. And I tell you, it wasn't easy to force them to back down, Madam Speaker. Again, for a party that called upon majority governments in the past to be more reasonable and to show more cooperation with the opposition, the message from the Premier was very clear. Speak all you want. I'm not changing this bill. You're all wrong, and I'm right. Which seems to be a message we heard again today during question period. Everybody's wrong, but he's right. It was clear, Madam Speaker, that Nova Scotians didn't believe he was right. And Nova Scotians questioned what the true motives were with Bill 100, which led to the significant debate that took place here, the significant presentations which took place. And when I hear the Minister of Justice tell us today that he did consult with the Barristers Society regarding the Forcible Entry and Detainer Act, the Streets Act, and the Indigent Debtors Act, that they agreed. These bills are no longer really useful. There's not a problem repealing them. But who else has been consulted? For a government that's looking to do strategies on everything, who else have they spoken with? Because I'm unsure myself, but there might be Nova Scotians that have concerns that these bills are being repealed. And so it is our responsibility, I believe, as an opposition party during these debates, knowing that it is being recorded on Hansard, knowing it is available on legislative TV, and Nova Scotians may be watching now, to tell them exactly what is in these bills to allow them to better understand and to see if there is some specific concerns. Because as I said earlier, when the minister stood up and named the bill, the Justice Administration Act 2011, it gives no indication of what changes are actually being proposed in this piece of legislation. Madam Speaker, as you know, the Civil Service Collective Bargaining Act and the Corrections Act and the Highway Workers Collective Bargaining Act applies to a significant number of civil servants in this province. If I'm not mistaken, the Department of Transportation Infrastructure Renewal is the single largest department as far as employees for the province of Nova Scotia. Any changes being made to that act, while the government may say it doesn't apply to private industry, it doesn't apply to private employers, the question becomes, will it have any negative impact on the employer, which in this case is not only the government of Nova Scotia, it's the people of Nova Scotia. We want to do everything possible to ensure that any changes being made here are in our best interest, because we have learned that this government will be very quick to dismiss our concerns by saying, don't worry, we have limited raises for civil servants to 1%, but failed to tell us what concessions were given in return and what dollar value is attached to those concessions. Today, as I mentioned, my colleague from Kings West attempted to find out exactly what is the financial impact to the taxpayers of Nova Scotia for the concessions that were given as a result of the most recent agreement reached with the Nova Scotia Government Employees Union. Minister of Public Service Commission refused to answer, gave a one-word answer. Obviously, it wasn't the open and transparent type of response that we were hoping that we would receive. But Madam Speaker, those are the types of responses that Nova Scotians will judge this government on, as to whether that's the type of responses they want from the opposition when questions are being asked about the taxpayers and the impact it will have on them on the agreements that they have reached. Now, Madam Speaker, I have to say it's a bit bizarre to hear the Minister of Service, Nova Scotia Municipal Relations, and the Premier tell us that ripping up the MOU that was reached with municipal units in this province will have no financial impact on those municipal units. I believe in the days and weeks ahead that those municipalities will be coming forward to tell us exactly what the implication is going to be. Because most municipal units don't simply plan year in, year out. They plan a number of years ahead. And they have been planning for next year, knowing they would no longer be responsible for housing or corrections. So any investments that were being planned are either not going to take place, or they will have to increase taxes to pay for them. That is a reality, and for the government to dismiss it, I think clearly is disrespectful of municipal units, but is a sign of a pattern. But with that, Madam Speaker, I think you indicate, unfortunately, my time has come to an end. I do appreciate the opportunity to have spoken on Bill number 7, and do look forward to hearing other speakers, and look forward to it being in the Law Amendments Committee as well. Thank you, Madam Speaker.
Thank you very much. I now recognize the Honourable Leader of the Progressive Conservative Party.
Thank you, Madam Speaker. Thank you for the opportunity to speak on this bill. It is my pleasure to speak today on Bill number 7, entitled An Act Respecting the Administration of Justice. I would like to pick up on the theme that was introduced by the previous speaker, Madam Speaker, because like him, and I suspect the rest of the members of his caucus, when I first saw the bill and its title, it sounded innocent enough. But you know, Madam Speaker, there's an old phrase, once bitten, twice shy, and it certainly applies to this government and in this case. Because although the bill looks innocent on the face of it, although it proposes innocent things like repealing 100-year-old laws and providing greater definition to the word arbitral and so on, Madam Speaker, we've learned our lesson with this government. We learned our lesson last fall when another bill, which had an innocent-sounding name, purporting to merge a variety of labor boards into one and to rename that board, purporting to create a labor management review committee for the purpose of reviewing labor laws, sounded innocent at the time. And in fact, that bill, Madam Speaker, was introduced in a very similar way. It was introduced early in the last session. It was called for debate very quickly after its introduction, before anyone could really study its impact. At that time, it went through second reading relatively quickly and went on to law amendments. It was only by the time it got to law amendments that an explosion occurred, an explosion of criticism, of concern, of fear from a variety of sources in business and industry. And it made it important then for, to be fair, both opposition parties to slow down the process and dig deeper beneath the surface to uncover the hornet's nest that was in fact underneath what looked like an innocent-looking bill. And so, Madam Speaker, here we are in the very next session with another innocent-looking bill, and it may well be an innocent act, but the government will have to forgive us for not taking their word for it a second time in a row. Because here we are again, early in the session, an innocent-sounding bill introduced on the first day, called for debate as soon as possible after that. And I think that as a result, Madam Speaker, it's only fair that we assure ourselves that the bill is what it is. For example, Madam Speaker, we learned from the last time that when the government says it consulted with affected parties, that sometimes they've only consulted with friendly affected parties. And so it begs the question in this case, on the amendments to the Civil Service Collective Bargaining Act, on the amendments to the Corrections Act, on the amendments to the other acts, what consultation has taken place? Our fear, obviously, is that they'll act today as they have in the past and only consult with one side of the equation, only consult with their friends and the NSGEU and other labor bodies. But I think when we're amending acts of this magnitude, when there are this many employees involved, when there's this size of a potential effect involved, that we need some assurance that lawyers that represent employers as well as employees have weighed in on the purported innocence of these amendments, that employers, public and private, as well as their collective bargaining units, have weighed in on the purported innocence of the changes that we see before us. These are things that a responsible government would do before introducing amendments of this type. That didn't happen last time. It fell to the opposition to make sure that all affected voices were heard. And so we intend, of course, to do our job and assure ourselves that that has been done. Previously, we may well have gone to the bill briefing and heard about the consultation that had taken place and seen the stakeholders there and been satisfied that the government had done its job and was introducing fair changes. Now we don't have that luxury anymore because of what happened last fall. After all, this is a government that created a committee to review labor laws, and they called it the Labor Management Review Committee. That would imply that there were representatives of labor and management on the committee. After all, both are in the name. But yet, as we dug deeper, we found out that 70% of management, 70% of the employers were left out of representation on the committee altogether. They didn't call it the Labor and Some Management, the ones we like, Committee, or All Labor and a Few Selected Management Review Committee. They called it the Labor Management Review Committee. A bill, finally, the government saw at least enough light in the last session to make some changes under massive protest by not only the organized business groups, but hundreds of affected companies, employers, lawyers who are experts in their field, and others. Work that you think would have been done before the bill was introduced in the first place. Now we need to assure ourselves in this bill that that work has been properly done. Because, Madam Speaker, as I say, on the surface, it appears innocent enough. How can you argue with providing greater clarity to the word arbitral, unless it means more than the bill says it means? And it's a shame, Madam Speaker, that in 2 years we will come to the point where we can no longer take the government at its word when it comes to labor laws. And Mr. Speaker, Bill 100, which we've spoken about here today as an example, is not even the only example. The government only brings labor changes to this House when it absolutely has to. It has used its regulatory powers in Cabinet time and time again to make major structural changes to the labor management relationship, to the collective bargaining relationship in this province in its short time in office. The government has seen fit by the power of regulation to Madam Speaker.
Order.
There's been
order, please. The honourable member, leader of the official opposition, has the floor. Sorry, as of the Progressive Conservative Party has the floor. Excuse me.
Thank you, Madam Speaker. I know some people are extra touchy about that, Madam Speaker, so I appreciate the correction. One thing about Bill 68, I'll just address this for the record so that we have facts here today, is that, first of all, it was an act of this legislature. It wasn't done behind closed doors in Cabinet, a major difference between that time and what I'm talking about. And secondly, for the record, it was actually before I was a member of the Premier's office staff. So I thank the member for bringing it up. Having said that, when one looks at the regulatory changes that have been made to such important fundamental collective bargaining principles as whether you need to pay for your union card, how a union goes about getting recognized, whether you need to actually have a certification vote or whether you can just sign up enough members on a sign-up sheet, areas of law in this province that have worked well and struck the right balance for decades that are now radically different and done behind closed doors. It's only when the government is forced by law to come to the legislature do they do so, and even then we see that under cover of an innocent sounding name some pretty radical changes can be made, and it's for those reasons that we express our concern about where we are today with this particular bill and move forward to do our work to ensure that it gets an appropriate examination by others who are experts in their field or who are affected by the bill itself. I say this because I'm amazed that the government would be opposed to allowing the bill to go through that process. After all, that is a responsible act, whether you're on the government side of the House or the opposition side of the House, that we take our time and make sure that bills do what they say they are going to do. There is the law of unintended consequences. I would argue in the case of Bill 100, we actually had the law of intended consequences. Now we have to be fearful of both unintended and intended consequences, and Bill number 7 that we have before us today deserves that examination. Having said that, Madam Speaker, I do want to move on to the remaining sections of the bill that specifically look to repeal some very old pieces of legislation. The Streets Act, the Forcible Entry and Detainer Act.
It's getting a little difficult to hear the member. If I could ask for a little, just quiet things down a little bit, please. Thank you. The Honourable Member for the Leader of the Progressive Conservative Party.
Thank you, Madam Speaker, and I appreciate your intervention. You're doing a great job at making sure that the members present are riveted to my remarks today, and I appreciate that. The government has taken some steps in this bill to eliminate some century-old pieces of legislation, century-old and unused for that amount of time. Well, Mr. Speaker, anytime we're looking to remove regulation from the books in an orderly way, I think we should be supportive of that. Having said that, why are we stopping at 3? How were these 3 determined? Why are they in a bill that otherwise deals with collective bargaining issues? These are questions that remain unanswered. But not to be one who would be opposed to removing useless laws from the books, I will say this: why stop there? This is a government, after all, that constantly tells people that they were elected to make change. They promised real change. They're making real change. That's what they say. Of course, pretty much every Nova Scotian is still waiting to see what that change is, Madam Speaker, and have concluded that it was all talk. It was all talk. That is, immediately upon getting into office and shedding themselves of all the promises they had made to Nova Scotians in the last election, they got very comfortable. They got very comfortable in their cabinet seats, very comfortable in their seats on the government side of the House. So when they looked at all of the laws of Nova Scotia, this government that was elected promising change, when they looked at the statute books in detail, when they looked at 150 years of history since Confederation, 140 some years, they could only find 3 bills, 3 acts worthy of repeal. That is hard to believe, Mr. Speaker, Madam Speaker, for the thousands of statutes in the books of the province, that this group that promised such radical change is happy with all of them except for 3. That is hard to believe. I think that's why, Madam Speaker, that Nova Scotians have concluded that it's the same old or worse. That the only acts they have a problem with are the Streets Act from the 18th century, the Forcible Entry and Detainer Act from the 19th century, the Indigenous Debtors Act from the 19th century. All the rest are fine, apparently. And then we add more every session. And Madam Speaker, I would call on the government to do a thorough review and bring back a true list of useless, wasted, out-of-date, unnecessary acts and regulations for repeal. That is something that we could be supportive of. Let's get on with the job of eliminating the red tape. Madam Speaker, it's interesting to know that one of the things this bunch did when they got in was eliminate the Red Tape Reduction Task Force, which had been a very important part of the Treasury Board that was responsible for doing just this, to constantly, ever vigilantly be looking for regulation that was getting in the way of commerce or of daily life for a modern-day Nova Scotian, whether it be a person or a business. That one of the most responsibilities of government is to legislate, for sure, but it's an equally responsible government that looks to take statutes off the books when they become a hindrance to daily life in Nova Scotia, that looks to take statutes off the books when they become a hindrance to business, to commerce, to progress, to the generation of wealth, to the free exchange of ideas, to the free flow of goods and services around our province. This government, after 2 years, claiming to be different, has identified exactly three acts that they'd like to repeal. Let's get on with the job of truly modernizing the province, of during a thorough review, Madam Speaker, let's get on with the job of really making a difference in the lives of Nova Scotians, of really getting out of the way in the conduct of commerce and the generation of real wealth. After all, they're so fond of taxation. Surely they can see the benefit, even in the NDP, of having more income, more business, more people to tax. Who would be happier than the NDP in that happy circumstance? If we can clear this junk legislation out of the way for that purpose, then everyone's a winner. But they found only 3, and they're ancient. They're ancient. So let's get on with the job. I'm in favor of letting them go. I'm saying it's a baby step when we need real change. But let's get on with the job of truly making this province modern and dynamic and progressive and a great place to be. And that means making sure that the way that this legislature does its work is as modern and dynamic as it can be. So we're looking at laws from the 18th and the 19th century. Let's do more of that. But let's look at what we could do to make the legislature part of the 21st century. That is why I introduced the Modernizing Government Act, which I have no intention of debating today because that wouldn't be appropriate. But I only make passing reference to it, Madam Speaker, very passing reference, because the intent would be similar. That we look to ways to make this place as modern and dynamic, as progressive as it can be, so that it deals with issues that are important to Nova Scotians. The government must feel that Nova Scotians will be delighted to know that the Indigenous Debtors Act has been repealed. I went around my riding recently. It didn't come up. To be honest, the Estreats Act didn't come up. The Forcible Entry and Detainer Act didn't come up. Nova Scotians will watch what we're spending our time on here today and in this session and judge whether we're doing things that affect their real life. The government introduced this bill, and of course we have to react to it with the leeriness that we've learned is necessary in this case, which is what we're doing. But I'm telling you that they're going to judge us on the list of acts that the government has brought forward, whether they got the examination they deserve, for sure, which we're determined to make sure of, but also whether they respond to the real needs of modern 21st century businesses and families in our province. It's highly arguable whether this act does that. But if we could look to finding ways to make a difference in this House, to focus the House on issues that are important to Nova Scotians, to clear the government out of the way where it should be cleared out of the way, to find ways to require the legislature to debate issues that are important to Nova Scotians, whether it's tax, the economy, health care, our schools, I could go on, that many feel we don't spend enough time on those things. And you know what, Madam Speaker, I think they're right. I think they're right. We don't. I bet you there would be some that would say, spend some of your time repealing bills that don't make a difference to us as well. but they'd be disappointed to hear that the NDP thinks there's only 3 out of the thousands that are on the statute books. That's, I think, what they're going to conclude if they pay any attention to this bill, which purports to redefine what arbitrable means and eliminate these 3 old acts. This is, after all, the place, Madam Speaker, that invented democracy in our part of the world, not just in Canada, but in North America. This is one of the oldest legislatures on the continent. This is where responsible government was defined, right here in the library, all those hundreds of years ago, when the New World was looking for a new way of governing itself, when it was striving for independence, when it was striving for freedom. The very way we govern ourselves, not just in Nova Scotia, but in Canada and in North America, was defined right here. And now here we are in 2011, and we have an opportunity to redefine for a more modern time what a modern legislature is supposed to look like and is supposed to do, how we can open it up to a whole new generation of Nova Scotians, how we can invite them in, how we can give them some comfort that we're here to deal with the issues of today, the ones that matter in their lives, how we can give them some assurance that their elected government is held to account for the decisions it makes, for the actions it takes, for the legislation it chooses to bring into the House, and use modern technology to do all of these things, whether it's Skype or Twitter or Facebook or video conferencing or video committees or virtual meetings. There are many, many, many thousands of Nova Scotians who could take a greater interest in the work of this chamber through the use of modern technology. There are many, many, many thousands of Nova Scotians who would want to take an interest in what we are doing in this chamber if they had some assurance that we were dealing with issues that are important to them. Today we're dealing with 3 bills, 3 acts that haven't been important to them for over 100 years. I'm not opposed to that. It's a good start, but it is a tiny, tiny baby step in what we should be doing to make life better for Nova Scotia families and for businesses and to create real opportunity and real wealth. Madam Speaker, with those few points, I will take my place just with this conclusion that we have work to do to further examine the labor parts of Bill number 7, the parts dealing with the Civil Service Collective Bargaining Act and the Corrections Act and so on. Although we're in favor of the repeals of the bills that the government is proposing, we do it only saying we wish they would find some way to identify more than these meager 3 of the thousands of bills that are on the books. And having said that, I look forward to discussing this in greater detail through the rest of this reading today and then beyond today as we go through an examination of what the government is proposing. Thank you very much.
Thank you. I now recognize the honourable member for Bedford Birch Cove.
Thank you, Madam Speaker, and I rise today to speak to an act respecting the administration of justice. This bill expands the jurisdiction of tribunals which fall under the Civil Service Collective Bargaining Act, the Corrections Act, and the Highway Workers Act, some of the same ones we dealt with under Bill 100. It accomplishes this by removing the word arbitral to eliminate possible confusion over the jurisdiction of interest arbitration boards, and the changes will only affect public sector employees. This bill also repeals 3 acts, the Estreats Act, the Forcible Entry and Detainer Act, and the Indigent Debtors Act. Now, these acts have not been cited in 100 years or more, and they, quite frankly, appear to be a cover for what's actually in this bill. Our problem is, after our experience last fall, we're deeply suspicious of anything that comes in with a number of different parts to it. Last fall, we were told that there had been extensive consultation on Bill 100. And there had. but there had been extensive consultation on only one part of Bill 100. And so there we were with a bill that referred to other bills and you know, was requiring some research to figure out exactly what was going on with that bill, and you know, sent it off for some further research with a lawyer. And so there we were, believing the government, and then what we discovered was, in fact, no, there hadn't been extensive consultation on the parts of that act that dealt with unions. And it was not just the labor boards that this bill dealt with. And so we had to begin filibustering it. And you know, I have to admit, it was the first time I'd ever been part of a filibuster. It was kind of exciting in that sense. But you know, I also felt very sad because it wasn't necessary. There could have been some consultation, and there wasn't around that part of it. And what we saw when we went to law amendments, and again, that was my first time at law amendments, so that was a learning process, was that we had one set of lawyers saying one thing and another set of lawyers saying another thing, which probably for the lawyers in this room is not unusual because that's what lawyers do. But it was disconcerting for me because I knew what I was being told by the lawyers that we had consulted, and I knew what the business groups were telling us that their lawyers were telling them, and it was diametrically opposed to what the government's to what the labor union lawyers were saying, which was, oh, this will have no problem at all, and it's not going to affect anything, and it's going to be fine. So it was disconcerting for me because I thought there should be some way that we could come to an agreement, and in the end, you know, it was the government did make some concessions for which we thank you and we were very pleased about, but in the end we were not happy with the bill and we had to vote against it. And so now we find ourselves back here again dealing with more issues that stem from what happened last fall. And last fall we asked for a delay in the passage of that bill. Because we really felt that there needed to be more discussion around the issues that had been raised by the various groups. That did not happen. And I guess what the government has never explained clearly to us is why there was such a rush on, why we couldn't have gone back, why we couldn't have discussed this more fully, why we couldn't have you know, made some changes to make sure that the businesses who were so deeply concerned would not have those same concerns. But the government used its majority and rammed the bill through, and here we are back again. And as we said at the time, we said, you're going to have to come back and make changes because there are issues here. And here we are today. Our concern around this bill is that it's a justice bill, and yet it's dealing with labor issues. And I guess this is a definition of an omnibus bill. I always thought an omnibus bill would be bigger than that, but it's clear to me that there are a number of things that, you know, remember when we watched Sesame Street with our kids and one of these things is not like the other? Well, 3 of these things are not like the other. And it's clear to me that this was part. You know, it's fine to get rid of bills. I don't think we were sending people to debtor's prison or anything like that anymore. Well, actually, I know that, but I just think that it's an odd pairing, and so of course that sets off alarm bells for us. And as the old saying goes, the leader of the third party cited an old saying, and I'm going to cite a different saying. Fool me once, shame on you. Fool me twice, shame on me. We're not going to be fooled again. We were... Oh, gosh. No, I think he got it wrong. Yeah, exactly. What we do not know is yes, we understand why the Estreats Act, the Forcible Entry and Detainer Act, and the Indigent Debtors Act need to be repealed. But what we're not clear on is why they need to make these changes now in the other acts. Why we had a technical briefing on this bill, and the notes for the technical briefing were twice as long as the actual bill is. But at no time has the government actually explained to us why we're doing this and what is happening to make these changes necessary. And because of what happened last fall, we need to know that. We need to know what is going on, and so that these changes need to be brought in. Now, in terms of arbitral, there's a lot of notes on what arbitral means and things like that. But arbitral is an adjective, and it's relating to or resulting from the use of an arbitrator to settle a dispute. An arbitral tribunal or arbitration tribunal is a panel of one or more adjudicators which is convened and sits to resolve a dispute by way of arbitration. The tribunal may consist of a sole arbitrator, or there may be two or more arbitrators, which might include either a chairman or an umpire. The parties to a dispute are usually free to agree the number and composition of the arbitral tribunal. In some legal systems, an arbitration clause which provides for two or any other even number of arbitrators is understood to imply the appointed arbitrators will select an additional arbitrator as the chairman of the tribunal to avoid deadlock arising. And last fall, when we were engaged in this battle over Bill 100, we heard from a lot of businesses. I heard from a lot of businesses in my own riding, and they were deeply, deeply concerned about what they were hearing and what they had not heard. What they had not heard was consultation from the government. And what they were not hearing was anything that gave them any comfort around issues of card check certification and issues like that. So for us, we really felt that we could not, go down the road of just believing the government. We felt that we had to draw a line in the sand. We felt we had to stand up for small businesses in particular. And in the end, what we have seen, and we've just had some appointments come through the Human Resources Committee for agencies, boards, and commissions. What we have seen is that there are people being appointed to this board and its proceeding, but what we don't see on that board are any people from non-unionized workplaces. And on that board, you have people who are employers in unionized workplaces, and you have people who are employees in unionized workplaces. But there are people who are employers or employees in non-unionized workplaces for whom the decisions at that board will have effect. And so for us, we could not simply turn around and say, yes, this is fine, we'll do it, whatever you want. We felt that we had to take a stand on behalf of the small business employees and employers in this province. And we just, and those concerns have not gone away, and in fact, they have multiplied by some things that we have seen since then. And we'll be dealing with that later during this session. I think one of the members earlier was suggesting there had been no effect from Bill 100, and in fact that member is wrong. We have seen effect from it, and we will be dealing with that as time goes on, but obviously I'm not going to outline all that right here, right now. Just going to have a glass of water. In terms of arbitral tribunals, I'll just talk a little bit about what they are, and by all means, yes. Ad hoc arbitration proceedings are those in which the arbitrators are appointed by the parties without a supervising institution, relying instead on the procedural law and courts of the place of arbitration to resolve any differences over the appointment, replacement, or authority of any or all of the arbitrators. And institutional arbitration proceedings are those in which the arbitrators are appointed under the supervision of professional bodies providing arbitration services, such as the New York-based American Arbitration Association, which conducts international proceedings through its Dublin-based branch, the ICDR, the LCIA in London, or the ICC in Paris. Although these institutions and many others are headquartered in their respective cities, they're capable of supervising the appointment of arbitral tribunals in nearly any country, avoiding the need for parties to involve local courts and procedures in the event of disagreement over the appointment, replacement, or authority of any or all of the arbitrators. And under appointment, it says the parties are generally free to determine their own procedure for appointing the arbitrator or arbitrators, including the procedure for the selection of an umpire or chairman. And I think this is one of the things we actually objected to in the in what happened last fall, that businesses could very well be affected by the decisions that were taken by this new board, and yet they would have absolutely no input into it. And because the government would not stop, slow down, consult some more, give businesses the reassurances that they needed to go forward, that decisions that were taken there would not affect them. I mean, they were saying that, but quite frankly, business wasn't comfortable with that because there was nothing in there to back it up. It was they felt empty rhetoric. For that reason, they were deeply uncomfortable with what was going on. And what you can see here is from this definition of what an arbitrator is. Ideally, you would have all parties to the arbitration actually participating in the appointment of the arbitrator. But if you're outside the whole process, if you're not even included in the process, then that's not really fair, and it's not really a true arbitration if it's going to affect you, but yet you're not allowed to have any input into the choosing of the arbitrator. And it does seem to me that worth noting that there's a word that's very close to arbitrator, which is arbitrary, and I'm sure that the employers and the employees of non-union shops felt that they were being subjected to arbitrary measures by this legislation. Or rather open shops, I guess I should say, felt that they were being subjected to arbitrary measures over which they had absolutely no control, but which could fundamentally change the way they do business. And so, of course, we had extensive concerns about that, and we still have extensive concerns about that. And for the reason that last fall we were told one thing, that there had been extensive consultation and that business approved of what was being done. And when we found out, in fact, that was not the case, and that business had the same concerns that we had come to upon a fair amount of research, the same concerns that we were expressing, and that's why we had to do what we did then, and that's why we have to do what we're doing now, which is slowing this down. This bill was introduced, I believe, last Friday, and here we are, and it's Thursday, and bam, we're on to second reading, and then we'd go off to law amendments, and we really just think that even if we don't have a Senate here, we need some sober second thought on this. Yes, we did get rid of the Senate here a long time ago. I mean, here, the red chamber, right? So anyway, we were talking about appointment of arbitrators, and the parties are generally free to determine their own procedure for appointing the arbitrator or arbitrators, including the procedure for the selection of an umpire or chairman. Now, if the parties decline to specify the mode for selecting the arbitrators, then the relevant legal system will usually provide a default selection process, and characteristically, appointments will usually be made on the following basis. If the tribunal is to consist of a sole arbitrator, the parties will jointly appoint the arbitrator not later than, for example, 28 days after the service of a request in writing by either party to do so. If the tribunal is to consist of 3 arbitrators, each party shall appoint 1 arbitrator not later than, for example, 14 days after service of a request in writing by either party to do so. And the 2 so appointed shall forthwith appoint a 3rd arbitrator as the chairman of the tribunal. Now, if the tribunal is to consist of 2 arbitrators and an umpire, then each party shall appoint 1 arbitrator not later than, for example, 14 days after the service of a request in writing by either party to do so, and the 2 so appointed may appoint an umpire at any time after they themselves are appointed and shall do so before any substantive hearing or forthwith if they cannot agree on a matter relating to the arbitration. Most arbitration clauses will provide a nominated person or body to select a sole arbitrator if the parties are unable to agree. For example, the president of the relevant jurisdiction's bar association or a recognized professional arbitration organization, such as the LCIA or a relevant professional organization. In default of such a provision where the parties are unable to agree, an application for an appointment is usually made to the court. A well-drafted arbitration clause will also normally make provision for where a party to the dispute seeks to cause delay by refuting to make or agree to an appointment. And you know, I'm sure that the businesses would have been happy to agree to have some representation on that particular board, but again, they were not allowed to. They're shut out from having some representation on there. It's not that they're delaying or anything like that. They can't even get a body on it. Often this will allow the non-defaulting party to appoint a sole arbitrator and for the arbitration to proceed on that basis. But again, these are people who are being shut out from any such procedure.
Order, please. We're now approaching the moment of interruption, and so I would ask if the member would entertain a motion to adjourn debate on Bill number 7.
I wish to make a motion to adjourn.
Thank you very much. And the motion to adjourn has been made. All in favour? Those opposed? Motion carried. I now recognize the Government House Leader.
Thank you, Madam Speaker. Madam Speaker, that concludes the government's business for today. Tomorrow, after the daily routine, Mr. Speaker, Madam Speaker, we will be going into debate on supply, and I wish you to now rise for us to meet from the hours of 9 a.m. to 3 p.m. Thank you, Madam Speaker.
Thank you. The motion on the floor is that we now rise to meet again tomorrow, Friday, April the 8th, from the 9 a.m. to 3 p.m. All in favour? Aye. Those opposed? Motion carried. It's now the moment of interruption, and I now call under Rule 5.5, as read earlier today, resolution put forward by the honourable member for Inverness. The resolution reads, Therefore, be it resolved that all members of the legislature urge the NDP government to stop downloading their financial hardships to the backs of hard-working Nova Scotians and admit that the broken MOU is just another hidden NDP tax. I now recognize the honourable member as the leader of the Progressive Conservative Party. Thank you.
Cumberland South. Yes, both. Thank you, Madam Speaker. It is my pleasure and delight to rise and speak in support of the motion today, in support of the resolution. I feel compelled, however, as I begin my remarks, to engage in a bit of fact-checking, as is becoming too often the case with this government. When things are said either in question period or in debate in this House and even outside this chamber that leave many Nova Scotians and certainly all of us on the opposition shaking our head at how it's so necessary to separate fact from fiction when it comes to this government. For example, just today, Madam Speaker, there were any number of points made by members on the government side that clearly are crying out for a fact check. For example, it was stated that municipalities have budgeted for these changes a long time ago and there'll be no effect on municipal budgets. I won't point out who said that, but it was certainly said. Well, Madam Speaker, that is deserving of a fact check because it's not factually accurate. One need only check with municipal officials in places like the town of New Glasgow, the town of Truro, or the Halifax Regional Municipality, or any of our municipal units who had actually done their budgeting on the what should have been safe assumption that the MOU would be honored and continue to its logical conclusion. And we're budgeting for the coming year and for the rest of the years under the MOU for a phased reduction to zero in covering the costs of things like corrections and education and public housing. Now they have to go back and do those budgets over again. And they have to put those costs back up to the old rate. This is actually a matter of hundreds of thousands of dollars. I can give you the specific example of the town of New Glasgow, who has done it exactly the way I've just described. I've met with them and seen it myself. It means hundreds of thousands of dollars to them. In fact, since we're on the theme of facts, over time it will mean $321,000 in extra cost downloaded to the town of New Glasgow. And that is just one example. And that is a matter of fact, Madam Speaker. So I think it's important that we have fact checks from time to time in this House. And where are they going to go to cover those extra costs? Well, there's only one place, and that is to the property taxpayers of the town of New Glasgow. And so they will be facing that kind of increased taxation for that reason. It was also stated in this House, Madam Speaker, that the agreement's not broken, that there's a notice period, that we gave municipalities, or the government gave municipalities 1 month or 1 year's notice. Well, that's true of every agreement. But it doesn't mean, Madam Speaker, that people therefore shouldn't rely on MOUs or agreements with the government of Nova Scotia when they sign them, because they contain notice periods. No one could conduct business with anyone else if we didn't have some faith that a contract or an MOU would be seen to its end date in a logical way. But when you haul your counterparty in on the last day of the notice period, on short notice, and inform them that you're triggering notice, that you haven't worked together with them on how, if you need to make changes or you believe you need to make changes, you can best accomplish that. If you just tell them at the last possible moment that you're triggering the notice period, that is not treating your counterparty with respect, and that is what we are talking about on this side of the House, that is no way to honor the spirit or the letter of an important agreement like an MOU. And thirdly, just on the theme of fact-checking, Madam Speaker, it is a matter of fact that the services under the MOU, public housing, corrections, and education, are services of the provincial government. It was stated by a very senior member of the government side today that these are municipal services. But that's just not right. No, senior. That is very senior. They don't get much more senior. But that's not right. Everyone knows that education and corrections and public housing are provincial responsibilities. The government merely forces a bill onto municipalities to recover a portion of the provincial cost. After all, the municipalities don't design our education policy. They don't have a say in our corrections policy. This is a cost that they get without any input into how that cost is managed. That's a great unfairness. And I think many property taxpayers in our province would say to the government, with a lot of common sense, they might say, what does our property tax have to do with public housing, corrections, and education? This is why the MOU was signed in the first place, because property taxes are meant to pay for services that property owners consume, like water and like sidewalks and street clearing and their share of the cost of the town or village or municipality that they live in. That's what property taxes are for. It was not intended that property taxes cover education, corrections, and public housing anymore, because it didn't make sense. The MOU had a lot of common sense behind it in terms of who pays what. The Minister of Finance goes on and on about user pay versus general taxpayer pay. That very principle was being honored by that MOU, as was common sense. But common sense was broken, was violated, when the minister ripped up the MOU in front of the municipalities a few weeks ago. That is what really happened here, and that is why this resolution is so important today, Madam Speaker. I am very proud that we have a critic for integrity in government. It's a shame that it's needed, but